Our next panel, I think, will be really interesting. So it's called Trump 2.0, the impact of the election on SEC enforcement. We actually had a similar panel the day after the election in D.C., which was very interesting, but now we know a little bit more, and I think this one will be even more enlightening. So let me start off by introducing our moderator, Andrew Ceresney. He's a partner in Debevoise's New York office and co-chair of the litigation department. Prior to rejoining Debevoise, he served for nearly 4 years as the director of enforcement at the SEC, and he was also previously in AUSA in the Southern District. Andrew, welcome.
Thank you. Thanks.
Next to Andrew is Jennifer Hall. She's a managing director in BRG's capital markets accounting practice. She's a CPA and focuses on forensic investigations, financial statement analysis, and compliance. Jennifer, great to see you. Next down the line, Littman. She's a partner at Willkie, Farr in Washington, D.C., and co-chair of the firm's Securities Enforcement and Digital Works practice groups. And of course, Christy previously served as chief of the SEC's Crypto Assets and Cyber Unit. Welcome, Christy. Thank you. Next is Kevin O'Connor. He is, as of this month, the Senior Vice President, General Counsel, and Corporate Secretary at Lockheed Martin. Before that, he was Senior Vice President and Chief Legal Officer for Carrier. But Kevin has also had a really illustrious public service career, including serving as Associate Attorney General of the United States, U.S. Attorney for Connecticut, Senior Counsel in the Enforcement Division. Kevin, thanks for joining us. Welcome. And finally, Steve Peikin, a partner at Sullivan and Cromwell based in New York. Steve previously served as co-director of the Division of Enforcement at the SEC and also as an AUSA and chief of the SDNY Securities and Commodities Fraud Task Force. Steve, great to see you. And Andrew, let me turn it over to you.
Great. No, thanks, Bruce. And thanks, everybody, for being here. This is going to be the best panel of the day. Let me just say that up front, because we got a great panel of people. Let me just first start off by sort of setting the tone for this panel. I mean, the bottom line is, obviously, elections have consequences. And if we didn't know that until this recent election, we now know it. We can change into this new administration. And as last week demonstrated vividly, both in terms of things that happen at the SEC, but also things that happen at DOJ and other parts of the government. Things like the hiring freeze, which will have major consequences, revoked offers, and things obviously relating to DEI, changes in leadership, a new acting chair now, changes in crypto, as we're going to talk about, a new crypto task force. And all of this has happened literally in like 8 days, and without even a permanent chair, which will happen very soon. We all know, many of us know Paul Atkins, and he will be a very strong chair. He is a known quantity, and there will be big changes, I think, at the SEC, certainly. But how radical a change will that be? You always hear new administrations, new priorities, changes, but the question is how radical the change it will be. So our hope today is to at least start to answer that question. Obviously, the answers will come once we see what happens, but today we'll try to render some predictions. So why don't we start off, Steve, maybe you can start us from an enforcement perspective, what we're likely to see. And
Yeah, I mean, I think, one thing that's important to keep in mind is that the Commission has a broad landscape to police, and across administrations, regardless of who's, in the chair's seat, there's a consistency. The Commission is always going to bring enforcement actions for Ponzi schemes and offering frauds and accounting and disclosure cases and insider trading. That doesn't vary. So the real question is what happens to the balance, the 20% or 25% of resources, like what does a chair and their senior staff choose to do with those resources? And I think if you look at the last 4 years, what we've seen is a few trends. One, an allocation of substantial resources to untraditional areas of enforcement, and I think in my mind the two are cryptocurrency and digital assets, and the other is record keeping. I don't think any administration has ever devoted resources to those two areas. The second is, I think, a willingness to advance, what I would say, some would say describe as aggressive, I would say controversial legal theories, some of which have met with success, some of them have been met with failure. And in particular, a willingness to sort of shoehorn facts into broad statutes or rules that don't have any real definition. So, internal accounting controls and 20647 policy and procedure requirements. And so we've seen some facts kind of shoved into those and cases advanced on those theories. And then the third, I think, is penalties, which have ratcheted up. People say it's a one-way ratchet, but all ratchets only go one way. The penalties have gone up significantly. So what do we have coming in? We have not a Republican administration, we have a libertarian majority commission. And I think, as Andrew points out, they're a known quantity. I think you can read, Hester and Commissioner Ueda's dissents and have a good sense of what they agree with and what they don't agree with, and they're the proteges of the incoming chair. What do I think? I think you're going to see a reallocation of resources away from crypto and record keeping and back toward more traditional things. I think you're going to see a pullback from the willingness to advance legal theories that don't have a lot of precedent or definition, more traditional legal theories. And I think, you're going to see penalties, retrench. I think that these commissioners believe that, particularly for issuers, that, penalties have to be cabined by a corporate benefit. I'm not sure whether that applies to registrants, but I do think that you're not going to see the kind of outsized penalties. And I think there'll be probably, it's going to be a more industry-friendly commission. I mean, those are sort of how I think. I would say, just to give you a grade on my ability to prognosticate, the last time that I had this conversation was with clients after I left the commission, and I said, this is a career bureaucratic staff, and there's inertia is a very powerful force, and things are going to be much more the same than they are going to be different. And I think I've been proven completely wrong over the last 4 years. So
we're recording this, Steve. We'll play it back for you. Christy, why don't you pick up on that and give us your thoughts?
Agree with everything that Steve said. I will say I think the incoming Chair Atkins he's a rule of law guy. I don't think that the enforcement is going to stop. And I also don't think, just because the commission has largely been focused on regulatory violations in the enforcement division for the last 4 years, that that means that all of you big firm lawyers here are going to stop getting cases, right? I mean, it's not just going to be Ponzi schemes and insider trading. It isn't the case that large companies, large financial institutions, large corporations stopped engaging in practices that they would have been charged with fraud for in the past, and we certainly saw that under Clayton and all the prior chairs. So that hasn't been where the resources have been allocated for the last 4 years, but those violations are still there, and so I think we're going to see just a return to that focus on fraud-based investigations, including at the institutional level, not just a focus on individuals.
So, Kevin, there has been a blizzard of rulemaking in the last 4 years in a host of areas. I mean, I just kind of looked up and was like, how many areas can be covered by rulemaking, proposed rulemaking, and then in many areas, actual rulemaking? There's going to be a shift, presumably, there. What are your thoughts on that?
Well, I mean, yeah, I think from the in-house perspective, it's just been a boomerang. We were frenetic during the Biden years with SEC climate regs. The amount of money and time we spent preparing to comply with the SEC climate regs was astounding. And then, of course, the court stepped in and stayed it. And it's not just the SEC. Remember, it was the FTC non-compete ban. What the hell does that mean? Is state law relevant or not? And we felt a little bit like, we were under siege. I'm not so sure things are going to be much different because of the pace at which the new administration is moving. But I can tell you, not having to comply with that SEC climate reporting regime is a huge benefit to public companies. I feel a little bit differently about cyber. I always felt the SEC had a much better nexus to justify cyber reporting by public companies because that is an existential threat to us. I never really saw that for most public companies, that climate change was something that was material to our investors. And I think from us, there's a little bit of a deep breath of thanks that I believe will now be dead. But there will be more to come. I mean, I think it's been a fascinating time for all of us trying to adjust to these sort of rapid swings in our political climate. I've never seen anything like it in my lifetime. I mean, just what's happened in the last 8 days. And, you know, I think to the outside public, it doesn't seem like a big deal, but if you're sitting in a government agency or you're sitting in the House and you're trying to figure out how to do this, it's a real challenge, which is why we rely on great outside lawyers like all of you. But I think fundamentally the issue, I think what's going to happen is for the last 4 years, it was conservative lawyers going to federal courts in Texas and otherwhere to try to put a spike in the wheel to stop it from turning too quickly. I think the state attorney generals now are going to try to do the same thing to the Trump administration. So we have to watch very closely what's happening in courts. And I will tell you, when they stayed, for example, the mandatory vaccine, at a company like Carrier where I worked, we would have had to terminate 70% of our US factory employees. It was incredible. And a judge stepped in, nationwide stay. I think what you're going to see now on the other side is I think Democratic state attorney generals and progressive legal groups are now going to run to the courts and see if they can get relief from the pendulum swinging too far in the opposite direction. And we're sort of in the middle waiting to see how it plays out.
Kevin, I guess the question's going to be which court, because I doubt they'll be going to Texas.
I think that's right.
But we'll see. And you know, I guess the question is, are we going to see, like, the last 8 days, the term flooding the zone has been used many times to describe what's happening, and you wonder whether that, you know, I don't know whether that's going to be the SEC as well. But all right, so Jennifer, tell us, in the financial reporting space, traditional area for the SEC, but we're likely to see some changes there. What are your thoughts on that?
Well, there is some data in the audit and accounting industry that, particularly when considered together with Trump-era priorities, could preview some characteristics of audit and accounting enforcement actions during the next 4 years. So the data that I'm referring to is data from accounting restatements. Previews at least 3 topics that I'll cover pretty briefly. One, it reveals pressure on gatekeepers. 2, high priority accounting topics. And 3, restatement data shows trends with the strength or weakness of internal controls over financial reporting. So first, the oncoming pressure on gatekeepers. Here's the data. Big R restatements as a proportion of total restatements has increased in the very recent years. Big R restatement occurs when previously filed financial reports are deemed unreliable by the company or its auditors. So big R stands for reissuance, whereas a little r, the accounting error is corrected in regularly scheduled financial statements. So little r is revision. And the difference between reissuance and revision is, of course, materiality. So a greater proportion of big R restatements raises questions about how material mistakes are going unnoticed, not just by auditors, but by other gatekeepers as well, internal gatekeepers. So the second revelation from restatement data is high priority accounting topics. So what I mean by high priority accounting topics is just areas of accounting that are going to get increased attention. If you remove the SPAC effect from accounting restatements, the #1 topic over the last several years is revenue recognition. Likewise, enforcement actions involving revenue recognition are a mainstay due to the importance of revenue as a standalone measure of a company's health. The new administration may choose not to pursue cases about unintentional revenue errors, but in part because of pressure on publicly traded companies to meet Wall Street expectations, deliberate fraud cases are very likely to continue. I mean, we're still going to see cases about fictitious sales and fraudulent overbilling, improper timing of revenue recognition. That stuff just isn't going to go away. But now a third piece of data from restatements that I think is useful for predictions is the number of accounting issues per restatement. A restatement can cover 1 issue or it can cover 17. The maximum ever really was 17 accounting issues that were restated by AIG in 2005. And of course, multiple issues indicate weak internal controls over financial reporting. A more recent maximum is not 17, but 6 accounting issues. Recently, there was a restatement by a software company that restated 6 accounting issues. That's a bit of an outlier. The average number of accounting issues is actually declining to 1.5 issues per restatement, which might indicate an industry-wide improvement in accounting controls. So by that measure, and especially when coupled with Trump-era priorities, there may be fewer enforcement actions about accounting controls.
Okay, well, I guess we'll see. Although I do have to say, just one comment on what you said was a question about auditors and what is going to happen now post-Jarczy and with 102E proceedings, not administrative proceedings is the only venue for those proceedings, and the last administration dropped a number of those cases, and I don't think has reinstituted any since. So I guess we'll see what happens with that and what the new administration does there. That'll be interesting to watch. All right, so that's setting the stage, but now we'll go deeper into a number of areas. I want to start with some process issues because I think we're going to see some changes in process areas. And I want to focus first on 2 things: formal order authority and the Wells process. Paul Atkins has been very vocal over the years about the Wells process and the importance of it, and also about formal order authority. And I've heard stories of when he was a commissioner and formal orders being questioned and the like, and potentially. So, Steve, why don't we start with you? What is your prediction about what will happen with formal order authority and with the Wells process?
Well, formal order authority is either going to be pulled up entirely to the commission or limited in delegation to the director of enforcement. I mean, personally, I think it's a huge waste of commission resources to be focused on formal order authority. If you put someone in who you have confidence in as director of enforcement, who understands your vision and your priorities, they can exercise that judgment. I think in the time I reviewed hundreds of formal orders, I wish I didn't because I got recused from a lot of things after I left government, but I think I probably didn't sign a handful, maybe of 3 or 4, and so.
And what caused you to reject those, like as a general matter?
One I happen to know was opening a matter that I had actually represented someone in the same investigation, and it had been closed, so it was a duplication, and the other was kind of a dumb thing that was never going to result in a case. But mostly the staff is judicious in what they recommend. Will it be pulled up? I don't know. But I don't think it's going to be delegated to 50 senior officers. And, when I was at the commission, it was sub-delegated just to the co-directors of enforcement. And, I don't think that was a, log jam or anything like that. And it allowed us to exercise some degree of control and understanding of what was in the docket, which, you can debate whether that's a worthy policy goal or not. On the Wells process, I think that there has been an unfortunate, backing away of the process. And something that I think has been core to the SEC's mission for a really long time is to make people have the opportunity to have their voices heard. The refusal to have Wells meetings, I think, was a bad decision. Not sharing the record, which has happened to me, routinely, where we don't get access to the record. What's the point of having a Wells process if one side doesn't see the evidence? So I think these were poor policy choices. And frankly, I don't understand it. The Wells process was my favorite part when I was director. So, I don't understand, why would you not want to have the opportunity to hear the other side's arguments and engage with them? So, everybody gets to set their own priorities. That one I didn't really understand or agree with.
Yeah. So, Christy, tell us about the impact if formal order authority gets pulled up to the commission. What impact does that have on the staff?
I mean, I agree with Steve that it's a little inefficient, right, for the commission to have to review all of the formal orders. As it is, or at least when I was there, they get a report every week and have the ability to pull up or to call for a vote anything that they look at and they have questions or concerns about. And I think that's something that was common when incoming Chair Atkins was a commissioner. And so, it wouldn't surprise me to see a continuation of that type of approach. But I think Steve's right. Also, you can, if you're properly messaging through the director to the senior officers across the division, then you should be able to get your arms around kind of opening of frivolous investigations or investigations that are really kind of a reach. But I do think what that means is you are going to have fewer formal orders, right? I mean, I think that people are going to be more measured and more considered in what they will open and how they want to spend their time.
A lot of informal investigations.
A lot of informal investigations.
Informal requests.
Yes, yeah, voluntary requests. So I think we're going to see fewer formal orders just because the staff will have to be more judicious in requesting them.
Yeah. I was going to say, Andrew, when I was a baby lawyer at the SEC, you had to get commission approval in the 90s for a formal order. And then I went into the U.S. Attorney's Office, and I was amazed that a first-year AUSA could whip a grand jury subpoena out in criminal action and send it without telling anyone.
Yeah.
And I thought to myself, that is kind of insane. Just to get subpoena authority, you have to take it up in a U.S. Attorney's Office for the most part. I mean, if you're subpoenaing a U.S. Senator or a member of the press, that's different. But generally speaking, in a white-collar case, an AUSA can send a grand jury subpoena on a criminal matter with no oversight.
Yeah.
And yet in the SEC, in a civil investigation, you had to go through these hoops. So I never understood why you wouldn't delegate that authority.
Yeah, well, actually, I did the opposite way. I started in the U.S. Attorney's Office and went to the SEC. In the U.S. Attorney's Office, not only could you issue a subpoena without checking with anybody, you could actually issue an indictment with the deputy chief sign-off, which is basically one person reading your indictment and then signing off on it. Now, obviously, higher profile indictments have more process, but it is a much different process. I mean, the number of eyes on every action memo at the commission, like, I don't know, we actually counted them at one point, 2 per person. And it was like it was over like a 3-digit number, basically, so.
On the topic of wells, I do think that we are likely to see a lot more. I don't, TBD whether they're going to actually kind of like reissue a new guidance or manual on wells notices. But I think especially over the last couple months of this last administration, we saw the process really kind of like thrown out the window. And I think my hope is that we'll see a return to having, some actual reverence for the wells process. And we know that Commissioners Peirce and Ueda read your wells submissions and really consider them and question the staff about them and want to kind of test whether the staff has good answers for the arguments that are made by defense counsel. I think I think maybe they've been the only ones recently doing that. And so I think, it'll be nice to have a majority of the commission who's really reading these documents and being considerate about how they, use their charging authority.
So another procedural issue, well, actually sort of procedural and substantive, I guess, in some respects, is specialized units. I went to a departure event last week of a couple of NIRO folks who were wonderful unit chiefs, who are actually sitting in the front row right there. And it was a wonderful event. And one of the things I really, as director, felt was that the specialized units, and Christy, I'm going to ask you to speak to this first, as a former specialized unit head, were very important innovations, thanks to Rob Kuzami and his innovation of putting those in place. And then, over time, obviously, they transitioned a bit, but have, I thought, become very strong areas of expertise within the Enforcement Division, and also allow people to specialize in particular areas, and I think really have brought great case. On the other hand, there's a view that those specialized units, are drilling down into areas and bringing cases maybe that go too far, and that's another view. So, Christy, what's going to happen with the specialized units in the new administration?
I think I would be surprised if there's not at least a look at the units and a question of whether all of them are appropriate. There are some units like asset management unit. I do think that is very specialized, and the expertise that they've developed, and even kind of like the sub-expertises across the asset management unit, are really important. And so there are a lot of specialized units that I think are really important, and you have to, particularly for registered entities, it's a good idea to keep those in place and to make sure that you have groups that are dedicated to kind of keeping current. But that being said, I think, and I don't think it's specific to specialized units. I think across the entire division, they'll look and say, where are we seeing efficiencies? Where are we seeing inefficiencies? In terms of allocation of resources and allocation of personnel. And I don't think the units will escape that scrutiny to the extent that there are units that are, their mandate isn't clear, or they're not bringing cases in numbers that kind of justify their existence. Questions are going to be asked about that.
Obviously, crypto. We're going to talk about crypto separately in a minute, but obviously the crypto unit, I think there'll obviously be changes there as well. Maybe a new name for that unit, or maybe disbanding of that unit.
Yeah, I mean, to be determined what happens with crypto, but I think we're still, I know we're going to talk about this later, we're still going to see fraud actions, right? We're going to see fewer purely regulatory actions, but I do think we'll still see fraud cases. Whether you need a specialized unit for that, I don't know. I mean, even outside of the unit, you have people working on crypto cases across the division. So it's
one of the things that the units do is ensure, to a great extent, consistency of treatment across a class of cases. And if you hold, as I did, an important policy goal of the Commission running a consistent national enforcement program instead of 12 different fiefdoms running their own programs, the units do serve an important purpose in, ensuring, maybe not with complete perfection, but equal treatment of similar cases, no matter where they're being handled.
Yeah. Okay. So let's move on to another topic: waivers and disqualifications. This has been a topic perennial. I mean, it started when I was director and started to become a very controversial issue, giving waivers for disqualifications, particularly to financial institutions. There was very difficult to get a waiver, a WIXI or bad actor waiver back when I was at the commission. Then, in the Clayton administration, there was a different view of these, and there was also sort of a kind of an explicit recognition that the decision about disqualification is somewhat connected to settlements and some explicit, I wouldn't say coupling, but some policy about those. And then obviously in the last administration, again, probably a very hard, much harder to get waivers, although there were sweeps and there were waivers of bad actor, particularly when the triggering was a compliance consultant or something else like that. So what are we likely to see in the disqualification/waiver context? And in particular, what I'm interested in is, like I've always said, like if there were a Republican administration and you had you could do whatever you wanted and you had a list of things that you're like, let me go make sure that I get these done. One of the things on that list is to make those disqualifications not automatic, because that is what's triggering the waiver. The automatic disqualification, if you made them not automatic, you wouldn't have to get a waiver, and that would solve the problem. Now, that could probably be done through both rulemaking and legislation, depending upon the disqualification. But Kevin, do you have thoughts on that issue, particularly as somebody who was in-house and thought about these issues from that perspective?
I must say I haven't really thought about it on the disqualification side at all. So I'm kind of agnostic, to be honest with you, on it, not to avoid taking a stance. It just really hasn't been an issue we've dealt with.
Yeah. So, Christy, Steve, thoughts?
Look, I think the votes have always been separate, right? The waiver recommendation comes from CorpFin or IM or both, and the enforcement recommendation comes from the enforcement division, and the commission votes on both, often at the same time, right? At the same moment in time. But the practical reality is for respondents or defendants is that they really do need to know, right? Whether or not you're going to accept a settlement may very well be dependent on whether there's going to be a disqualification that you get a waiver for or not. And so I think it's maybe a little naive to think that they're not related.
Yeah, I mean, I think when Chairman Clayton put in place this policy, basically said, if you offered to settle and you didn't get the waiver, you would have an opportunity to withdraw your settlement offer. That's the practical reality. That's always existed, right? Could you imagine you call up, big bulge bracket investment bank, say like, congratulations, your settlement's approved, but you're disqualified from, from half your business.
Bad actor.
And then you say, and then they say, well, I don't want that settlement anymore. And then what the commission's going to say, I'm sorry, too late. No backsies, right? I mean, so that was just recognizing kind of the practical reality. I mean, the automatic disqualification is a bad policy choice, and the commission has not been, pure in its approach. I mean, the idea that, the commissions have said, repeatedly, oh, these are individually considered facts and circumstances decisions. But then in the text messaging cases, everyone got them in a blanket way. That's just hypocritical.
Right,
you know?
right. No, definitely. Well, if you're making a list of things that you should put on the list to get done in this administration, that is definitely one of them. All right, so let's move on to a couple of other issues. You guys, one other, again, this is substantive, obviously, but you guys touched on penalties, and I just want to spend a few minutes on that. Obviously, there's going to be a difference in penalties. You mentioned the penalty guidance, the 2006 penalty guidance for corporate issuers, corporate benefit, and that being a guiding principle. No question that's going to sort of govern, and I remember all of the attempts to try to find corporate benefit and see whether you could justify a penalty or not. I'm sure that will happen again, and DERA was very integral to that process. I'm sure they will be again. But what about, to me, the more interesting question is like registrants, and you referenced this. I remember, when I was at the commission, even the Republican commissioners on registrants kind of took a different view. Like registrants are, you're essentially, registered with the commission, you have different obligations to your clients and the like. And so are we likely to see a reduction there? In the last administration, I should note, for violations for registrants, multiples, like you go and you say, you get a demand of X amount, you'd be like, well, that was 4 times the last highest penalty. And they say, well, that's where it is, precedent doesn't matter. And so, what are we likely to see in that realm?
Yeah, I mean, I think there's going to be a reduction in penalties, and whatever the cases that got the most attention were the original waves of the text messaging off-channel communications penalties, which were, I think, the commission's penalties were 125 million and 75 for the for the CFTC, and I think they were pretty shocking to a lot of people. The one thing I would say is, if those cases had been $5 million penalties, practice would not have changed. And so, they served a purpose. Now, maybe you didn't need the sledgehammer, but they did serve a purpose, a deterrent purpose. But is this commission going to have an appetite for penalties of that size for registrants? I don't think so. So I think you're going to see a dampening of penalties across the board.
Yeah, I think, when you're in-house, all you're really looking for is a way to articulate why the number is what it is to your board. You have a False Claims Act. How much did you overcharge the government? Treble damages. It's very easy to articulate where the government is, no matter how big the number is. I find with enforcement actions, oftentimes, it's just somebody decided that's the number. And it really makes it difficult to sell that to your client, because they're just saying, well, why is that the number? And how's that not going to harm our shareholders? Aren't we trying to protect investors? And I find it's most challenging with SEC type enforcement cases to be able to articulate large penalties to boards of directors than it is with a lot of other government enforcement actions across the government. And, so my view is, it's not so much how big or how large and whether this commission's more aggressive than that. It's, can you articulate why? And it can't just be because we want to beat what Peikin did when he was here for this type of case. But there is a sense of that each commission or each enforcement division's trying to one-up the last one. Well, Ceresney got 100 million for this kind of violation. I'm going to get 150 million. I get it. I was in enforcement. On the other hand, that's not really helpful to corporate America in terms of articulating the consequences of misconduct, if you're really at the luxury of people trying to one-up. And I don't mean that as a criticism of any particular enforcement director, but if you want a corporation to write a big check, you need to be able to articulate to that corporation exactly why it's that number, not a higher one, not a lower one. And I find at times that's very challenging.
Yeah. I think that this is a problem of the commission's own making. So for a long time, the commission has itself touted its effectiveness of its enforcement program by how many cases did you bring and how tall is the pile of financial remedies, right? That's been, and it's very hard for somebody to come along and say, those things don't matter, because the commission's been saying it matters for decades.
Well, that's where I was going to go to next. In preparing for this, I found a shocking statistic, which was FY 2024, there were 124 actions that were part of sweeps. There are probably more, but these are 4 sweeps. The off-channel communications, 55 cases, beneficial ownership disclosure, 36 cases, marketing rule, 17 cases, Reg BI, Form CRS, 16 cases. And that's probably like more than a quarter. It's probably a third, I think, of the total for that fiscal year, maybe, give or take. And and that's pretty shocking. I mean, Paul Atkins has been very vocal about stats not being the measure of the enforcement program's effectiveness. On the other hand, Congress, stats are stats, and Congress can measure stats. It's like crime stats. I mean,
They want to know what they're getting for the money they're appropriating.
Right, and why did it go down, and why does your budget need to be at a certain level?
I mean, Chairman Clayton said, I don't care about stats. And I said, yeah, you don't care about them because we've made sure you don't have to care about them, right? Like, you can't have the stats fall off the cliff and then go to your overseers and say, I need the same amount of money this year, even though I did half the work. You just can't.
So are we gonna, prediction, Mr. Peikin, we're recording this.
Look,
what number of enforcement, standalone enforcement actions in FY 2026?
Well, I hope for whoever has our seat that they don't fall off a cliff. The commission has a lot of people working there, and they're supposed to do a job, and they're supposed to have activity that's largely
Did you
consistent.
give a number? I didn't hear.
It's called answering the question you want to
Chrissy,
answer.
do you want to give a number?
I'm not going to give a number, but
You're not going to give a number?
There's no shortage of securities fraud. It's not as though there's not work.
All right, I'm going to go out on a limb and give a number, 350. We'll see if that turns out to be right.
Well, right,
Standalone enforcement
And I
actions.
think I don't care if you're Department of Justice, SEC, you always have that quantity versus quality debate, right? You're a U.S. attorney or head of enforcement, you want to deploy people on big, sophisticated financial crime cases, you're going to put 20 enforcement lawyers on a case that might get you one stat. Meanwhile, you can go out and do a sweep and get 75 stats. And let's just face it, I agree with you, it's not the SEC driving this conduct, it's the appropriators who expect to see results for every dime they allocate to SEC, whether it's enforcement or otherwise. And so it'd be naive to think you can ever really get away from stats. The question is, can you manage your stats in a way that you keep the heat of Congress off your team? Because we've all probably been called up there to testify and been asked, why not more of this? Why too much of that? But how do you manage to evolve towards new priorities at the same time, not creating a perception that you're not doing anything anymore? In the SEC's case, I don't think they want to be accused of being unaggressive on securities fraud. So I'm guessing a new leader of that is going to be very mindful. He or she is going to have to figure out, okay, I can't ignore stats. On the other hand, there are real priorities, and if I have to throw more resources at the expense of stat here and there, that's what I'm.
So are we
I mean, you used a phrase that resonates with me, is manage the statistics. And, we spent a lot of time managing the statistics.
Yeah.
I don't mean in an inappropriate way, but making sure that the cases got delivered by September 30th. And you can't just let that process play out.
Yeah.
It won't work. You have to manage the docket.
So are we going to see some sweeps, or are sweeps a thing of the past, at least for the next administration?
It's usually at the end of the fiscal year.
Yeah,
Get the numbers up.
You can't ramp up a sweep that quickly.
Yeah. So they got to start. Are we still going to see some sweeps, though? I mean, is there going to be a Form 4 or a filing sweep or
I don't think you're going to see them for footfalls. Mm-hmm. Maybe you'll have some enterprising unit chiefs who come up with a fraudulent practice that they think is widespread and needs attention, particularly if it's returning money to investors. Mm-hmm. It wouldn't shock me to see something along those lines, but they're not going to be sweeps focused on rule violations with no investor harm.
Yeah. Now we've stayed away from crypto, and I know that there's probably going to be lots of discussion on it. But just briefly on crypto, and I want to focus here on the pending cases. You've got a number of cases against exchanges that are pending, including one where there's a motion for interlocutory appeal pending in the Second Circuit. You've got the Ripple appeal that's pending, and that's, as briefed, the initial brief was filed by the commission right before the administration change. What's going to happen to, because now we have this task force, it's going to look at crypto regulation more generally. I assume it's going to sit down with the industry and try to craft rules that make sense from an industry perspective, and what's going to happen with the pending cases. Christy, any thoughts on that?
I think particularly for non-fraud regulatory violations, they have to find an off-ramp that isn't continuing to barrel towards a final judgment where there's not a registration regime, right? At the end of the day, even if they win those cases, are you going to go to a federal judge and say, require them to register even though that's not possible, or shut them down? I just think that that's not a practical ask for a federal judge, and so there's got to be an off-ramp that is going to be palatable to the defendants. and that doesn't have one of these kind of like dire consequences.
Yeah. Okay. Well, we've got about 5 minutes left, so let's talk about a couple of other areas. And Steve, you referenced this, I think, a little bit in your comments, and the prior panel did talk about it as well. There are a couple of areas. You talked about how a lot of enforcement, insider trading, Ponzi schemes, retail frauds, et cetera. Those aren't going to change, and that's clear. I used to say most enforcement is bipartisan. I mean, that's true. Nobody likes those things, and the enforcement division is always going to bring those cases. But there are the cases at the margins, and particularly when it comes to two areas in particular, internal controls, accounting controls, and the SolarWinds case is one where the court pushed back on the SEC's expansive views of the internal controls, use of the internal control statute, but it has been used expansively. And the other is the policies and procedures issues, where the requirement is that the policies and procedures be quote unquote reasonably designed, which if you know what that means, please come and tell me, because I can't figure it out. And there certainly hasn't been much case law on that. And we now, actually, I should note, the last administration brought the Silver Point case where we're going to litigate that case, and that's a 204A and 20647, failure to reasonably design policies and procedures. And so that's, we'll see if we get any case law on that eventually. So what's going to happen with those areas? Clearly, the Republicans have been very vocal that's not. Are we going to see any of those cases? Is it going to be a complete shutdown? Obviously, internal controls, you can have accounting controls. I understand that. But beyond that, are we going to see anything that sort of pushes the balance in that area?
Yeah, I don't think you're going to see a complete shutdown, but I think, I can imagine that the majority of this commission will say, were there sufficient, guidance to make clear that your policy or procedure or your control had to have these, provisions in it. And absent that, I could see a majority of this commission not approving settlement. And I don't think that was true in the last commission. So, look, there are going to be companies that fail the adequate internal accounting controls provision, and those cases will be brought. And there are going to be people who have inadequately designed policies and procedures. But I don't think it's going to be sort of the lesser included offense for the investigation that didn't work out.
Right. Right. All right. And another topic that I think is probably on some minds is whistleblower and the impact of a new administration on the whistleblower program. There's a lot of aspects to this, but just two that would be great to hear folks' views on. One is Rule 21F17. There has been no rule that has been enforced as frequently in the last 4 years in ways that I think people didn't necessarily envision when it was first proposed. Are we going to see a rollback of interpretations in 21F17? And are we going to keep seeing large whistleblower awards like we have? Or is there going to be, obviously there's a range, 10 to 30%, but there's, are there going to be new rules on that, or are there going to be a rollback in that? Christy?
I would be surprised to see these 21F17 sweeps continue. It's been radio silence for a little while, as far as I know. But I do think you're still going to see large whistleblower rewards. I also think it's an opportunity for whistleblowers where there is real fraud to come in and focus the staff on it. I think the staff kind of has to rely on that in a lot of circumstances. And so, the rumors of enforcement's demise are greatly exaggerated. I think there are going to be enforcement actions. I think they're going to be significant, and that's always going to be an opportunity for large whistleblower awards.
Yeah. Steve, any thoughts on that?
Yeah, I mean, we have a very sophisticated and capable whistleblower bar that continues to feed the commission, high quality whistleblower tips. And those will, if they result in cases, they're going to result in significant awards. And I don't think you should expect hostility towards whistleblowers from this commission. But and the one thing I would say is the process for adjudicating whistleblower claims has been made much more efficient over the last 5-7 years or so. And so those awards get adjudicated and paid out much more efficiently than they had been in the past.
Yeah, although there was that statistic that like 14,000 of the tips that were reported last year were from 2 whistleblowers. which I found to be remarkable. We'll see if they continue to.
Who's got the time?
Yeah, exactly.
14,000.
Exactly. Everybody in this room, find those 2 whistleblowers and try to get them. Anyway, well, I think we've hit on most of the important issues, but thank you all for a great panel. I think we'll replay this in a couple of years, and we'll see how well you guys did.